Great. Well, I think we are about at time. So welcome, everyone. So this is the 5th meeting of the Farm and Forest Modernization Program Rulemaking Advisory Committee. And so today we are going to really be going over the sort of final agency ideas for rule language proposals. So we're going to go through the different items that were in the 2 charges handed to us by the Commission. The original charge, which was established at the January LCDC meeting, and the revised charge that was provided to us at the April LCDC meeting. And we're going to focus on a couple of topics for which we've gotten a lot of feedback from folks over the past week, particularly. And I do recognize that it's a pretty packed agenda today. And so if we, don't get to something that you are particularly interested in or want to share additional thoughts on, again, we're encouraging folks to submit comments. We've set aside about an hour, maybe 15 minutes to review those outstanding questions and suggestions on the language proposals. And then at 2:15, we are going to move into sort of a discussion around the fiscal impact and housing impact statement for the rulemaking. And the materials that we provided on that are based on the language proposals that was in the materials packet. We're going to take a quick break then, a little bit before 3 o'clock, and then we'll spend the last hour today addressing the charge edition that from LCDC in April to talk about replacement dwellings. Okay, and then we'll close with next steps, and we'll review what's going to be happening over the rulemaking hearing period over the next couple of months. Okay, so let's kick off today with really, a very quick round of introductions, sort of more of a check-in with folks. And I'll go ahead and start. So if I haven't met you, I am Hillary Foote, and I am the current Farm and Forest Specialist for the Department of Land Conservation and Development. And with us, we'll go ahead and also introduce other key DLCD staff members who are with us today. So Gordon Howard.
Gordon Howard, I'm the Community Services Division Manager with the LCD, and I'll send it to Casaria.
Hi, good afternoon. Casaria Taylor, Senior Rules Coordinator.
And Alexis.
Yeah.
Hey, good afternoon. Alexis Hammer, Legislative and Policy Manager.
Great. And then I don't believe Commissioner Boyer is on quite yet, is she?
Not quite yet.
Okay, great. So go ahead and I'll go through the RAC membership list alphabetically. And just please say hi, introduce yourself, and the agency that you are representing. So Alyssa is going to be joining a little bit late today. So we'll go to Amber Bell.
Good afternoon. I'm Amber Bell, Planning Director with Lane County.
Great. Thank you for being here. Austin.
Hey guys, Austin Barnes, Marion County Principal Planner.
And Blair.
I don't see Blair.
Okay, thank you. And Charles?
Charles Bennett, Jackson County Planning. Good afternoon.
Great, thanks for joining, Charles. And Elaine.
Hi, good afternoon, Elaine Albridge with Davis Strait Tremaine. Olivia Jaman and I are tag teaming on behalf of the Oregon Wine Growers Association to participate in the RAC. Thanks.
Great, thank you. And Ken Katzroff.
Don't see Ken yet.
Okay. And Jim Johnson.
Hello, everyone. Jim Johnson, Land Use and Water Planning Coordinator, Oregon Department of Agriculture.
Great. I'm glad you were able to make it today. And Jan Lee.
I am Jan Lee, Oregon Association of Conservation Districts.
Great. Thank you for being here today, Jan. And Jeff.
Good afternoon, Jeff Kleinman, attorney in private practice.
Great. And Joy Lovett is also out today. Justin Green.
Good afternoon, Justin Green Consulting.
Great. Thank you for being here, Justin. And Catherine. I saw her earlier.
Catherine, can you unmute?
There we go. Catherine Daniels, former retired farm forest land specialist.
Great. Thank you for joining us this afternoon. And Lauren Poor.
Lauren Poor, Oregon Farm Bureau.
Great. Thank you. And today we have Stephen Shane from Washington County instead of Maitri. Stephen, are you here?
There we go. I am here. Hi, everybody. Stephen Shane, Principal Planner for Development Review in Washington County's Land Use and Transportation. Good to see you.
Great. Thank you for being here, Stephen. And Megan. Is Megan on?
Do not see Megan yet.
Okay, great. And Mike.
The McCarthy Family Farm. Thanks.
Thanks. And Mickey.
Mickey Killingsworth from Central Oregon, Simple Shepherd, and just me.
I like that introduction. All right. And Nellie.
Nellie McAdams with Oregon Agricultural Trust.
Great. Thanks for being here, Nellie. And Rob.
I'm Rob Halliburton, representing Friends of Yamhill County.
Great. And Rory is also going to be out today. Samantha.
Hi, Samantha Bear with the Oregon Property Owners Association.
Great. Good afternoon. And Tyler.
Tyler Ernst with the Oregon Forest Industries Council.
Great. Thank you for joining us, Tyler. And I think I saw Ken join. Ken, are you on today?
Yeah, I couldn't unmute. Ken Catherine, it's Robbie Williamson and Wyatt. Nice to see everybody.
All right. So,
Hillary, there is one person. It's just a telephone number 517 something. Have we? Is that one of the people who already talked?
That was Tyler. Yeah, that was Tyler Ernst.
Okay. All right. Thank you.
Great. Well, thank you, everyone, for being here today, and thank you for spending so much of your time, participating in these discussions over the past, several months. So, as always, we are encouraging members to, share your thoughts. That's why you're here. But also, if something occurs to you after the meeting today, or if you didn't feel comfortable speaking up, we still do want to hear from you. So please provide us any written comments. I'm encouraging members of the public who may be following along online on YouTube as well. Go ahead and send your comments to the agency. We do still want to hear from folks. And the written clarifications have been very helpful. So thank you very much for the folks who have taken the time to submit those written comments into the agency. And if there are topics that we've covered that you haven't provided comments on, we do, still want to hear those feedback. Feel free to do that. If you don't provide written comments, then what's reflected and what we'll be considering as we put together the final language for consideration for noticing is what you've shared in these discussions, which is reflected and captured in the meeting notes. So take a close look at those, make sure that they reflect your perspective accurately. And so I just stress that this is particularly important right now, as after this meeting, staff at DLCD will be re-reviewing all the materials that we've received along the way over the past couple months as we prepare for a final noticing. So noticing for this rulemaking is intended to go out on September 1st. And so we have a very little time really over the next week or so to get stuff together. And speaking of the noticing and next steps, I'll be reviewing those at the end of the meeting today. All right. So we do have a lot to go through today. we want to make sure hear from everyone. So please use the raised hand feature if you have comments you'd like to share. And I'm going to again ask Kasaria for her assistance in making sure that anybody who has a hand up gets called on. All right, so let's get right into it. So we're going to go over all of the charge issues today. And I'm going to start really with codification of case law for commercial activities in conjunction with farm use. This is a topic where we still have received, a lot of questions and comments. And so I want to make sure that we have time to really discuss that. And I'm going to break this out by sort of like the components in the proposed rule language so we can talk about that and solicit feedback on that. So we'll go through those sections sort of one at a time for sort of further comments here. So am I sharing my screen, Kasaria, right now? No, okay, let me try this again. There we go. Okay. So folks, we had quite a few comments on this. And so this first section of the proposed rule language for codification of the case law standards for commercial activities in conjunction with farm use really centers around the principle that was established in the sort of 1979 Ballin decision by LCDC. And that relates to a requirement that products and services provided be essential to the practice of agriculture. And so the way that we had it in our rule language implied an or here, that you could be a provider of products and services essential to the practice of agriculture or be exclusively or primarily a customer or supplier of farm products and services. And that the comments that we received, that didn't particularly capture the essence of the intent of the LCDC or the LUBA in the Sandy case here. And so there's sort of two approaches to address that concern that that we've seen from people, and a third one, which was the original proposal that we talked about earlier in March. And so we'd like to hear from folks who have concerns on this. I know, unfortunately, Rory is not here. He had a number of concerns on this. Is Blair on as well?
I am on.
Yeah. Do you want to start that off with your concerns about capturing Sandy adequately in Ballin?
Yeah, I think having the or, you end up really you're not really capturing City of Sandy at all because you don't have to comply with that ruling. And there have been both cases, and there's also been a Supreme Court case, that they're not alternate standards. They all apply. So if you were in a county applying for a commercial activity in conjunction with farm use, and the county failed to apply one of those criteria, someone could appeal, and they would go to LUBA, and they would say, well, you forgot to put the services essential to the practice of agriculture in the City of Sandy. And they would win because it's case law and it's established, and it's required. So I think either of these options would work. Option B looks a little clearer to me, just on first impression. But I think either of those would capture the essence. And I think it'd be very helpful because otherwise you're actually weakening what the law is. You're not really codifying case law completely. You're codifying a part, but leaving out a part and weakening the standard. So I think this is a good response to that problem.
Okay. So here in A, we've suggested potentially rewording it to state that a commercial activity in conjunction with farm use must be either exclusively or primarily a customer or supplier of farm products or services essential to the practice of agriculture, or B, which breaks it out, leaves it as is, and puts an and there. Charles, did you have some comments on that?
Yes, thank you. Let me put my hand down here. It's interesting because I'm not an attorney, so maybe the attorneys can get involved. But our land development ordinance actually has the or. And we do reference in our land development ordinance, the Sandy and the Craven rulings. And, you know, this was adopted, our land development ordinance was adopted and accepted by DLCD, LCDC. And so it's interesting that we have the or in our LDO, and I'm not sure how that will affect if the rule is changed to be and to be inclusive of all three of those, then I guess we would be less restrictive than the interpretation by DLCD, if I'm understanding that right. So I'm not sure. I don't know if anybody else can address that, but it seems like the rule or the land development ordinance as written was following those case laws. So that's a contradiction.
Yeah, and our model development code had the dreaded and slash or in it, which we cannot put into rule as well. So it needs to be an and or an or here. And option A sort of gets rid of the and by putting it into the sentence.
Larry, Gordon, Elaine, and Samantha have their hands raised.
Okay, Gordon.
Well, just one thing I wanted to point out is that case law developed because the agency did not have a rule in place. So if we were to adopt a rule, it would essentially, I believe, be the authoritative interpretation of that, and would essentially take over for case law in terms of applying the rule instead of applying trying to figure out what case law was. The other thing I wanted to mention, and I think Elaine may bring this up, is that Olivier provided an alternative in his comments, which went quite a different direction. Well, not completely different, but somewhat different direction, based on just a single, as I understand it, a single of one of the cases that, and we're trying to meld several cases together. So I just wanted to point that as well. And Elaine may be saying something about that. I see she has her hand up. So.
And we are going to address the Craven standard on the next page here and look at some of the language that Olivier had suggested as well. We want to work on this part of the proposal first. So Elaine.
Thanks, and thanks, Gordon. Yeah, I just wanted to direct the group to DWT's written comments that we provided into the record on June 20th that address this and state Oregon wine growers' opinions on the CAFU discussion. So we'll mainly rely on that, but I do just want to reference back that there is the Craven case, and then there's also some really great legislative history around permitted use winery statutes that discuss sort of the underlying intent to allow wineries and wine-related activities via a CAFU permitting CUP process. And so the discussion that we're having here today, I understand, is based on some piecemeal from prior LUBA case law, but really doesn't align with the earlier legislative history around these CAFU permitting pathways for wineries. So, and frankly, this test would be impossible for a winery or wine related activity to satisfy. So OWA doesn't support either A or B.
And so Olivier had requested the or, and also, which is at the end here, and also adding some additional language that was captured in the Craven case.
Proposed alternative language, yes.
Yeah, which would be the green part and the blue part added onto to see here. And so that just it expands a little bit more on what Craven, the principles of the Craven case here. So the way that it would be worded is option A would be in order to be a commercial activity in conjunction with farm use, you would be either exclusively or primarily a customer or supplier of farm products or services essential to the practice of agriculture, or enhance the farming enterprises of the local agricultural community. And OWG's suggestion was to which the farmland hosting that commercial activity relates, and that the agricultural and commercial activities must occur together in the local community, which are directly from the Craven case as well.
I'm sorry, Hillary. Are you trying to summarize what our comments were, or are you just describing what you're proposing here? Because that's different than what our comments are.
Yeah, I understand. I think the comments from OWGB were not to codify the 1979 LCDC case or Sandy
Who are you
case.
talking about? OWG? Or
Wine growers?
We're OWA.
Oh, so sorry.
Yep, and our proposed test that we presented was three-pronged. And it did not have the essentials to the agriculture or primary customer for ag. So it's the first prong was enhance the farming enterprise of the local community in which the EFU land hosting the commercial activity relates. To have the agricultural and commercial activities occur together in the local community, and 3, meet the standards of 215, 296. That was OWA's proposal for the CAFU test.
Right. And so we have, 3 cases that and Earl, pretty much talking about here, all of which are fairly old cases. Again, the 1979 Ballin decision by LCDC, the City of Sandy Luba decision that references Ballin and Craven, which I believe was 1986 or 1989, which is captured here in C and a new proposed sub B.
Hillary, you've got some more hands up as well.
All right. Who is, let's see.
Got Samantha, Austin, Blair, and Jim Johnson.
Okay. Samantha?
Sure, it's just 2 points. I just appreciate Gordon's comments earlier. That was why I initially raised my hand to say something similar, but I had to step away at the beginning, so I think I'm just a little confused from a housekeeping standpoint. Are we not working off of the language that was sent out in the materials? Or, because I'm not sure that this...
We are, and we're also looking at some of the comments that were received this week that were sent out on Wednesday.
Okay, so did we already cover the farm impacts test?
We have not gotten to that yet.
Okay, thank you.
We're starting at this because it seemed like most of the comments that we received this week were around the commercial activities in conjunction with farm use test. And that seemed to be an area where there was a lot of comments here. All right, okay. Austin.
Yeah, I just wanted to quickly say for my 2 cents, I think option B looks good. It's straightforward. It's clear. It appears clear to me, and I think would be clear to an applicant. So that's all I've got. But option B is looking good for me.
Okay, thank you, Austin. Blair?
Hi, sorry, I didn't mean to jump in line again. But when you asked me my question, we hadn't scrolled down to the second page. So that's not acceptable to have if the enhance the farming enterprises of the local agricultural community is a separate standalone test for CACFU, then you're not requiring requirements with the City of Sandy and the other cases in LCDC's interpretation. I think, and this is also later in our comments, so you're not there, I think to address the concern of the wineries is when you're listing what types of uses can be allowed as CACFUs, there's explicit legislative authorization for them to continue to apply as CACFUs. And so they don't have to have anxiety about this language and try to weaken it because of their anxiety. Just say wineries are still allowed as CACFUs. I mean, I don't love that policy, but the legislature made that policy, and they have a valid argument that that was the policy and what the legislature wanted to do. And I don't think anyone's trying to undo that here. So I just say spell it out, and then make the standard reflect what all of the existing case law is, not just one case. And if you have just enhanced the farming enterprise, the local ag community, that's pretty much, Katie bar the door. It's very, very low bar. And it's just ineffective. So I would like to help the Oregon wine growers by making explicit that they still have that provision, because they do. And I don't think anyone's challenging that.
So, Elaine, what are your thoughts on doing a conforming rulemaking to capture
That's just not good
215,
rulemaking. That's just not good
456?
rulemaking. And honestly, the LUBA cases don't take into account the legislative intent that's dating back to 1989, around the time of Craven. And the tests that we're talking about today doesn't take into that account. I mean, the policy arguments behind it, they specifically address wineries, but there's obviously the recognition that CAFUs were supposed to allow a variety of different types of activity. And the way that this is being narrowed, I think runs afoul of that. So,
so I'm hearing that you wouldn't want 215, 456 codified in rule, or reflected in rule, rather.
The CAFU, I mean, I think the 215, 452 permitted use winery is separate from the wine-related activities that can take place as CAFUs. So I mean, honestly, when we got this material, notwithstanding the comments we've provided, wine-related activities or wineries are not even listed in an example of commercial activity in DLCD's language that would be acceptable. And so I think it's hard to say expressly that this type of activity is allowed, even though it doesn't meet the test. So we need to review that more closely before providing a opinion on it. But I don't. It seems like the issue is the test prongs. So I'll leave it at that.
So the 215, 456 is the statutory language that says wineries may be reviewed as commercial activities in conjunction with farm use, and the alternative to 215, 452 or 453, along with the conditions that go along, the income restrictions, right, for incidental retail sales and stuff like that. So I think one of the suggestions would be to put that into rule, like in this new rule section, if that would help clarify.
So you'd be saying that they are allowed by rule, notwithstanding the fact that they can't meet the test, the CAFU
so that's
test.
interesting. Why does wine growers feel like a winery couldn't meet the CAFU test under the standard, under the essential
either be exclusively or primarily a customer or supplier of a farm product and provide products or services essential to the practice of agriculture. I mean, farmers like to drink wine, but it's not essential to the practice of agriculture. I think that it makes it incredibly difficult burden to carry to demonstrate those two prongs of the test.
Are they not a customer of farm products?
A winery?
Buying grapes?
I don't know. I don't know how someone would interpret that. I think it is very subjective and poses considerable risk that A and B would be denial factors for wineries or wine-related activities, like a tasting room. Yeah.
Okay. All right, thank you. Let's move on to Jim.
Yeah, I was actually a part of the discussions when the legislature was looking at this element. I was working with Richard Whitman on the language, and the whole idea behind 215, 456 was to kind of carve out that wineries could be approved as a commercial use in conjunction with farm use, regardless of the standards above. And so I would support something that would basically say A last element here that number one, I would support putting the case law in for all commercial uses in conjunction with farm use that are proposed. And then have another statement at the end that said, nonetheless, or regardless for whatever, wineries can be approved as a commercial use as in conjunction with farm use, subject to 215-456. And there's lots of precedent. There's lots of examples within LCDC administrative rules where they refer directly to statute. High value farmland's a great example where they refer to the statute itself as opposed to like whatever. So I would support and in fact I would point out to you, when I was at DLCD, there were several counties that took the Sandy case and incorporated that right into their code. And it is in several of the county's codes, and it's been used for a long time in several counties. Jackson, Clackamas are two examples for existence. But I know that when the winery things were being worked out, because I was in those discussions, wineries were specifically called out separate from other commercial uses in conjunction with farm use. And I think as long as your rule made that clear, that they wouldn't be applying the enhanced situation, for example, or whatever, that you would be fine.
Mm-hmm.
Just to clarify too, the concern is not just for wineries, but also for tasting rooms and other wine related activities. So it's activities without production as well as activities with production, because both are currently allowed under the CAFU process now.
Yeah, and I think you make that clear in the language. I'm looking at it right now, and you could say all of that as it relates to wineries. It shouldn't be relating to a yard and garden store that sells no farm machinery whatsoever, for example.
All right. All right, thank you for that suggestion, Jim. Mike and then Sam. Mike, you're on mute.
From a farmer's point of view and looking at this in Hood River for some time, I have a real problem with this whole section, commercial activities in conjunction with farm use. Number one, it turns out they're unenforceable. They're doing whatever they want to do. My biggest problem with it is wineries, cideries, breweries, and many other uses have no farm products they sell in any way, and there's no connection to the farm. And I think this is a real problem. And I'd like somebody to tell me how we enforce that. And so I'm really against this section applying to wineries, breweries, cideries 100%. They cheat and try to get around the rules too much. The other thing is in section C, that seems to invalidate A and B, because especially when you leave the second part on it, to which the farmland hosting the commercial activity relates. So it has nothing to do, the way I read that, it has nothing to do with the farming enterprises in the local community. It only has to do with the farming enterprise of the CAFU. So it seems, maybe I'm reading it wrong, but it seems to negate the effect. That's the first part of C. And then the other part is, what does enhance the farming enterprises of the local community mean? Does that mean we buy 1 head of lettuce or 1 pound of grapes from the guy down the road? Is that enhancing? Or does it mean in a community like Hood River, where we grow 350,000 bins of fruit, they buy 1 box of fruit? So I have real trouble with that without defining what that means. Thank you.
All right, thank you, Mike. All right, we'll go to Sam and then Lauren.
Well, I think that Mike's comments for me really highlight why this language is of so much concern, because I think a lot of the commentary that was just given is likely going to be similar commentary that's given when these types of approvals are being appealed or opposed at the local level. And I think that that is what Elaine is really highlighting on, of this language is highly subjective. And if the goal of this RAC is to provide clarity and is to provide, ease of implementation at the local level, I think this really sets up the opposite outcome likely occurring, because I'm really not sure how, this is certainly not clear and objective, and I'm not sure how an applicant is really going to successfully meet a lot of this burden And last, I guess I'm also a little confused of whether we're considering an or an and, like if this is supposed to be an or option, or if we are at this point talking about this being an and. So I have another comment on that, but if we're not considering it, if we're sticking with or, then maybe my comment's irrelevant. But I know that Thousand Friends had submitted comments about this needing to be an and test. And I think that that is also really problematic, especially when we get down talking about home occupations. I have no idea how a childcare facility is going to be essential to the practice of agriculture. And that is literally what the department recommends if you move forward with your other rules, would be for a childcare facility to apply as a commercial activity in conjunction with farm use. So I just don't know how it's going to be possible.
Okay, thank you. So a childcare facility would not be reviewed as a commercial activity in conjunction with farm use. It's a separate use listed in Chapter 215.
Well, I mean, we can talk about that when we get down to those, but that would potentially actually not be the case. And it's in the materials that one of the options that a child care provider could do is apply as a commercial activity in conjunction
as
with
a
farm
home
use.
occupation, not as a commercial activity in conjunction with farm use. Sorry.
Review when we get down there. Yep.
Okay. All right, Lauren.
Yeah, so I wanted to highlight I'm really struggling this, and it's to Elaine's point of when we're talking about rulemaking, I think this is very unclear, and it's not good rulemaking that when we know we have a problem with the rules that we're trying to draft, when we have to start listing out things because it's not clear enough, and so we know it's not going to cover something, so we have to put an exemption in already from the get-go. And so we have to say, oh, we're going to start listing things. And we have over 220 commodities in the state. And it's great for the wine growers that they have good representation on the rack, so they can be here and they can say how this doesn't work for them. And they have the legislative history to show that, and they can be on that list. But we can't haul in every commodity to apply the draft language and say, this is how it does work for me, this is how it doesn't work for me, and get them on a list. And so, I mean, I don't think in fairness or clarity, I mean, that we should be adopting language that we know already has issues from the get-go. And so maybe we should work some more to do what we set out to do, which is provide clarity. And it's also to Sam's point, if we know that there's issues with it already and we don't know how an applicant would meet this burden and there's issues, then it's not good language. And so maybe we should keep working on it until we find better language.
All right, so we did put in the list at Farm Bureau's suggestion from the first RAC meeting. That was a list of activities that might be considered as commercial activities in conjunction with farm use. So this is a list that's actually in a number of county ordinances, the same language in multiple counties that is reflective of discussions the legislature had in 1973, sort of what could be considered a commercial activity in conjunction with farm use. But we did get a lot of comments this week with expressing concerns, about the list. And so again, the list was included in response to Farm Bureau suggestion.
And I do appreciate the list. I worry that I don't know everything that can be currently happening again from then to now, and what has been approved and what would be approved and what could. So I worry that we could be missing something, and the language is difficult.
Okay. All right, thank you. And Nellie, then Jim, then Charles.
Thanks, Hillary. Yeah, I definitely agree in a need for clarity in the rules. And for me, when I read A and B, they seem pretty clear, and it seems like some counties have been using them already for decades. So I don't see a problem with A and B. C and the new sub B are less clear to me because I don't know the extent of what a local agricultural community is or what enhancement of that entails. Like those seem too subjective to me to be really additive here. I also think that adding an exception for wineries doesn't imply that the other test is unclear. It just means that you apply a different test when you're encountering a situation where there is a winery. And it makes some sense that wineries would be treated differently and have been treated so historically. They do produce a product that's ready for consumption, but I also want to share that I've been working with Napa Valley vintners on a project around land protection, and they have told me that since 1969 they've had an ordinance that has been pretty restrictive on non-agricultural activities that occur in Napa County, and that continues to have strong support from those winemakers. The operations manager I talked with there said that otherwise their valley would become Disneyland, and they actually prohibit all weddings. They have even considered legislation recently to prevent the sale of non-wine related materials at wineries, so like even baseball caps with the logo. So I just offer that as sort of an example of a county that has had sort of a more extensive experience with wine growing and some of their concerns and how they've been addressing them. I just wanted to share that.
All right, thank you, Nellie. All right, Jim, and then Charles.
Yeah, I wanted to address this, all these different agricultural uses not being, not knowing how they would react to this versus wineries. When the legislature was discussing whether wineries could be approved as commercial uses in conjunction with farm use, the Department of Agriculture pointed out that the Board of Agriculture had a policy in their resolutions that all agricultural uses should be treated the same. Thus, why were wineries getting this exception, but other agricultural products were not? And the response was that wineries are something different. That's part of the experience, so to speak, and that they were going to allow wineries to go through this, but there had been a discussion about other agricultural products, and the legislature did not go there. So that was the direction of the legislature at that time, to allow for wineries, but not other agricultural products to go through this process. I just wanted to point that out. And then it's interesting that Nellie pointed out the Napa County situation. I've been talking to some Napa County planners lately also, and it is interesting. It's gotten so congested down there, so to speak, to use a nice word, that Napa County has indeed stopped all new weddings. They will not authorize any new wedding venues or the like there, because it is basically has gotten too far, and they were not considering the impacts to actually farming operations by all these non-farm type uses.
All right. Thank you, Jim. All right, Charles, and then Ken.
There's a lot of good points on all sides here. I don't know if we're ready, if we're moving into the examples. I think we have a concern with the list of examples. I hear that they're from other counties, but those could be defined differently by the different counties. I think that it can be confusing, a veterinary clinic that has cats and dogs. Or there's different definitions, I think, in the slaughtering of animals, which including accessory retail and wholesale sales. I mean, there's definitions that are associated with this list. And so I think that the lists can create their own problems, of how they're being defined and by different folks. And so I would shy away from having examples. I think that's making it more confusing than clarifying the rule.
We've heard that from a number of people. All right, thank you, Charles.
Thanks.
All right, Blair. I'm sorry, Ken, did you?
Yeah, I'll be real quick.
You took your hand down, sorry.
Yeah, I did, but I was going to pause, but I think I'll provide one quick comment, or I guess two, which is, sounds like we've got a lot of differing opinions again, and I think it might make sense to take a look at this again. I don't know, I know we're on a short timeline, but I think that maybe there needs to be another round of comments on this and propose some rule language as a practical matter. The second thing I would say is that I go both ways on the list idea. In some ways, I really like it because it does provide some clarity. But in other ways, I think it's highly problematic because, for example, in one of my cases, DLCD specifically argued that farm equipment storage and repair facilities were a farm use and didn't require a CAFU. So I feel like if we're going to put a list up here, we need to make sure we're consistent on what it is because I don't even think the department itself is consistent then.
Okay, thank you, Ken. Blair, did you take your hand down?
No, I thought that was called on. Okay. Well, I agree with both Charles and Kenneth on the problem of the list. I think they both articulated why it is problematic, which we agree with. I do want to say some earlier comments about concerns that requiring all three requirements of the case law would make it really difficult and more difficult for folks to qualify for commercial activities in conjunction with farm use doesn't really make sense since it's already the law. I mean, it's already required. You're not making up. I mean, we have talked about LCDC's ability to make new policy. They may want to make new policy, but these criteria that we're talking about, these first three lines, are straight out of case law. It's just putting them in the rule. So if it's difficult, I mean, what I have also not heard are instances of legitimate commercial activities in conjunction with farm use not meeting the criteria and being turned down.
But Blair, I'm going to push back for 1 second. I'm sorry. I mean, Gordon's point was that the case law was adopted in advance of a rule. And if we adopt a new rule, that case law can change to be compliant with the rule. So I would push back on your point of we have to codify what case law says. We can change what the rule is, and then we'll have new case law.
But rule can't change statute.
Right.
Well, I understand that.
Right.
Obviously.
Who's talking? I can't see who's talking.
All right.
I see. Could I just finish what I'm saying, please?
Yeah, please finish, Blair, and we'll go on to Nikki, and then we need to move on to another topic.
Yes. Yeah. So we're going to hope LCDC can make policy and change policy, and they can change the rule, which is wonderful. But that's not what we were talking about on this particular part and this particular aspect of the direction. And there's been a lot of complaint about LCDC going beyond the charge, or the RAC going beyond the charge. This part was about codifying case law. There's other parts that aren't about, but this was part of it. And this is the case law. So I just don't see the objection to putting it in the rule. Yes, it can change later.
Great, thank you, Blair. All right, Mickey, and then we do need to move on to our sort of next topic real quick. All right.
Okay, so I'm the simple shepherd on here. So I listen to what the planners say. And in my comments, I put in, I didn't like the list because agriculture is always changing. And if you wanted to do the list, I don't think it should be in the rule. I think it should be a separate educational document for the counties to use because it's always going to be changing as agriculture changes. That was in my written comments. My other thing is I agree with Austin. I listened to what he said. I went back on my notes and looked at what the planners have said the last 3 meetings, and I like, codifying the case law. And if there's 3 examples of case law that's being used by LUBA in the courts, then in my opinion, that's what we need to use. That's it.
All right. Thanks, Mickey.
Hillary, if we could just let Samantha, if you could be very brief, we do need to move on.
Yeah, I'll be super brief. And I think I'd like to make this request because I think this dynamic is going to continue to play out, which is why at the last RAC meeting, I asked if the department could please make clear whether or not we are having, a conversation where the full merits of a new rule can be discussed. Can we talk about the policy implications, or are we just here to codify the case law? I think we keep bumping up against confusion from various RAC members of how far the conversation can go or not go. And so if someone at the department could just make that clear, then maybe we can things can move along a little bit more smoothly.
So on this particular topic, it is the charge of the commission to codify case law on this topic. And so that's what we're looking at right now. Yep. All right, so the next topic I did want to touch on that got a lot of comments was the evidentiary standard for the verification of income. And so this would be applicable to farm stands, to new primary farm dwellings and new accessory farm dwellings as well. And so we had talked quite a lot about an IRS tax return receipt as being used as a tool that could easily be obtained by folks with a click of the button. I tried it myself. It's pretty fast to get your documents. And you can also call them and have it if you don't have access online. It seems like a great tool. And so a lot of the discussion, so some of the comments that we received, were asking us to go a little bit farther and also maybe look at requiring counties to provide, get delivery receipts from applicants, to conduct site visits to verify occurrence of farm activity. And there were some comments around our conversation last time, which is whether this should be mandatory for counties as far as the farm stands go, or whether it should be, a heads up to folks that the county can request this at any time. All right, Mike. You're on mute, Mike.
I'm sorry. What if the county doesn't want to request? And that is an issue. So I think the county should be required to request at some period this information. So that's an issue, and we've been through this in Hood River County several times. The county is not willing to request the adequate information. That's number one. Number two, the Schedule F does not provide adequate information in any way to get to this issue. And the reason is because line 2 makes you say the basis or cost of all items purchased, but there's no division in there between what would qualify as farm stand produce purchased from Oregon or a nearby county. There's no way to separate that from mugs, hats, whatever else are non-qualifying in the incidental 25% category. So this really doesn't get at the 25% at all. And so I propose some wording that the counties should request information necessary to determine the 25%. And that's not the exact wording, but counties should request at some interval information necessary to determine. Thank you.
Thank you, Mike. Elaine and then Sam.
Thanks. My question was going to be about what is a IRS tax return transcript, and then Mike mentioned Schedule F. I would agree we would want to not be that specific, but allow the counties to require. And I don't know what's wrong with the existing language, which is accounting information with a letter certification from an accountant. So I'm not sure why that current evidentiary threshold is not adequate. So
yeah, thank you, Elaine. So there is language for wineries that requires, accountant statement, but that same language is not in statute or rule for farm stands or primary accessory farm dwellings.
I know some local jurisdictions have looked to that requirement and applied it to farm stands. I've worked on some projects that have had to do that, and it seems to work pretty well. And then it would create consistency across these types of rural uses. So My suggestion would be just look to that and incorporate that same language so that it's already being used and for other uses.
And we did have a long discussion about sort of accounting statements versus the verified tax return receipts at our last third meeting, I think it was. Yeah. All right, Sam, and then Ken.
Yeah, I agree with Elaine, and I don't think that the group at the third meeting agreed that IRS tax return transcripts or, what's existing for wineries is insufficient. Again, I think if the idea of this rack is that we're going to try to be doing things to make there be consistency and ease of implementation, then it should be what farms are already doing. And wineries often have farm stands, they have multiple permits. And so it would be kind of silly to ask a winery to submit one type of accounting information, but then a completely different type of accounting information when it comes to their farm stand. When I don't think there's agreement that would be insufficient. And then I also say I don't think there should be a requirement that counties do this. This could potentially turn into an unfunded mandate. This is going to take a lot of time and resources to obtain all of this information, maintain it in a secure way, review all of this information. I don't think a lot of counties actually want to be going through all of this. And so I think it should remain at the discretion of local governments entirely to whether or not they want to request this information.
All right, thank you, Sam. Ken, and then Lauren.
Yeah, so I don't see an issue with having a requirement of a sworn accounting statement or something of that nature. I think that when we start getting to IRS or much more detail, that starts to get very intrusive. And there would be significant business reasons why somebody may not want to provide an entire IRS tax return transcript. I also wonder if at some point in time that gets into some significant privacy issues, both under Oregon's privacy laws and any that may be adopted federally in the coming terms. So I would throw that out there because I do think if we want to have a rule that's going to be sufficient moving forward, why don't we take one that seemingly is working? So I guess I'm on the side of Elaine on this one. It's just a more practical approach, in my opinion.
All right, thank
That's all
you.
I got.
All right, Mike.
Hillary, you skipped Lauren.
Oh, I'm sorry. Lauren?
Go ahead, Lauren.
I accidentally
Oh,
checked my
yeah,
name
no,
there.
sorry.
Yeah.
I was just gonna flag, Sam briefly made the point, but I was gonna flag the piece about mandating the counties to do something in the work in the legislature. The state can't just mandate the counties to do things without making sure that they check that there's not a financial implication to that. And so I don't know if, unless it's already in statute, that they would have, that there's a requirement that they collect this information and then they've already done the evaluation as to whether or not there's a certain cost to it that is under a certain threshold. So I think we just got to be careful about mandating counties do stuff. I think that there's always, you can always do counties have the option to do things if they want to, but we have to be careful about telling them what to do.
All right, thank you, Lauren. All right, Mike, and then Jeff, and then we need to move on.
So what I hear people advocating for is that the county has to in no way seek compliance. And that really bothers me. What it means is that as a private citizen and a neighbor to a nearby circus next to me, I am the one responsible for compliance. I do not like that. These are laws, they're rules, and compliance is a requirement. And what you're saying is that I have to take all my neighbors to court because the counties won't do it. And I totally reject that idea. The other thing is we've worked very hard on the 25% several times, as I mentioned. The CPA one does not work. CPAs will either refuse to do it, and that's what we've had happen. We got a letter from a CPA that said, I do not provide comfort letters, and they furthermore said it's illegal to do so as a CPA. So I don't see how we can use that criteria. And it also said in there, in maybe it's a winery statute, a CPA or other qualified accountant. That really doesn't do it. And I still think the only way to have this appropriate, and I guess what I hear is people advocating that we don't want compliance. And I find that really difficult. But what we need is a language that says the county at the, say at a public request or something like that, that they are required to get the information necessary to determine compliance with the 25% rule.
Jeff, and then Sam, real quick, but we do need to move on. Yeah.
And I would agree with Mike, and I would go further and say that there's a distinction in terms of the possibility of an unfunded mandate. I don't think it costs counties anything to require that forms be submitted and placed in the file. So where the additional work would possibly come in would be in actually reviewing the material. But once it's in the file, other people can look at it at no expense to the county. So I just don't think the unfunded mandate business really is applicable here.
Thank you, Jeff. All right, Sam, real quick, and then we're going to move on.
Yeah, I respectfully disagree with Jeff. I think it is a cost element, and I bringing up what Ken said earlier, and I know the folks that I represent really don't want their tax information uploaded into a public record where people can sit, review them and likely sue them, which is likely what would happen, or file a complaint or whatever. So it is a pretty significant concern when we shift enforcement mechanisms to something that's complaint based to having to submit mandatory financials. And then I don't think this is about not asking, like wanting people to be in compliance. That's not what it's about. It's like, this is a new legal obligation and a new burden. And we talk about these, take it out of the land use context when we talk about labor or OSHA requirements or BOLI requirements or anything else. In every other space, there's a sensitivity to requiring small businesses to go through the economic and paperwork burden of having to do this, and having agencies, whether it's a local or state government, having to maintain sensitive information like this. So I understand that I think it's more nuanced than the idea of we just don't want compliance.
All right. Thank you, Sam. Okay, so we are running a little short on time. So let's move on to the next topic, which is preparation and the definition of preparation. So as noted in the materials packet that we are sort of felt like not enough time was given to the definition of processing. So we've sort of removed that from consideration. This is the revised definition of preparation. We had no comments on it, this week, but hopefully these edits clarify the concern and the intent. So the edits essentially read, split off, one definition for products or byproducts raised on a farm operation where the preparation is occurring. So like when, the preparation is just for products raised on the farm, that's covered under I. And if the preparation is related to products raised on other farmland, it essentially says that that another farm use needs to be happening other than preparation to clarify the intent of that original rule language. And then we added a phrase to clarify that when you're preparing products produced on other farmland, they should be in the same facilities that you're preparing products from your own farmland. All right, so I hope that clarifies the issue. So what this really gets at is if there is no farm operation, right, on the farm tract, which are lands under, the same sort of farm ownership. If there's no farm operation, there's no standalone preparation facility. A standalone preparation facility, not in conjunction with any sort of like farm operation, is reviewed as a CACFU. All right. So Sam?
I mean, I just want to say I really appreciate the changes that were made here. I think I had a lot of concerns about the previous options, and so I appreciate I feel like those were listened to, and I see this as a significant improvement. Um I am Could you just walk through B to the final line again about what to be in same facilities of what that the last line is a little confusing to me.
Okay. Yeah, so in this case, where products or byproducts that come from another farm are being processed, preparation is occurring only on a tract. So that's under the same ownership. So it doesn't have to be like co-located with your orchard or whatever. It's on the same sort of farm ownership. Currently employed for a farm use other than preparation, right? Because preparation is within the definition of farm use, right? So this changes the circularity of that definition previously. Such products or byproducts are prepared in the same facilities as and in conjunction with products that are raised on the farm operation where the preparation occurs. And so if you are, raising apples or pears and you are, preparing other apples and pears from the surrounding area, they're being prepared in the same facility and in conjunction with your own apples and pears, generally speaking.
Okay, so there just can't be essentially a standalone
right
building where nothing that you've grown is being processed.
Right. In that case,
Okay.
there are other types of land
Right.
available. Right.
Okay. Got it. Thank you.
Yep. Jim?
Yeah, I'd just like to say that this is really in line with where I believe my experience has been with preparation. I've had many cases over my career where a local government has argued that something like this requires a commercial use in conjunction with farm use, and I've argued the other side that it is farm use. And that case that we had out of Washington County years ago with a grass seeding facility was what led LCDC to have Ron Eber and I come up with some draft language on this issue years ago. And I actually like this better than what we came up with years ago. So I would say I support the direction you're going here.
All right, great. Thank you. Okay. So moving right along. All right, home occupation. So the charge here from LCDC was to consider whether uses that were otherwise listed in Chapter 215 should be able to alternatively be reviewed as home occupations, and which is a very broadly defined use category. And so the conversation that we had around this at our last RAC meeting, we heard from a lot of planners. They like the flexibility to allow smaller scale uses to be permitted as home occupations, and larger scale uses to be permitted as commercial activities in conjunction with farm use. So and then, so there's like 3 levels or 3 tiers of options. There's like the smaller scale home occupation. There's the use as it is authorized subject to standards in Chapter 215. And then there's the larger commercial activities in conjunction with farm use option, the multi-path permitting. So you need to figure out with your land use planner, like where you fit within that schema. So one of the ideas that the staff had to maybe put some limitations around a home occupation, so we avoid a situation where we have a large scale home occupation that is larger in intensity and in impact than would be otherwise permissible under the use standards in Chapter 215. would be to sort of clarify that a home occupation needs to be significantly less intensive than the limitations and conditions otherwise specified for the use. And so I'm curious about folks' thoughts on this. I know there are a lot of folks who don't like this, who would like to see the limitation proposed outright. And you know, we've heard earlier that planners do like the flexibility to shuttle smaller operations or proposals into this category. And we also had a lot of comments around putting a clarification there that a home occupation is incidental and subordinate to residential use of a dwelling on a property. Is there some concern that maybe that hasn't been so clear in some instances, although it may be obvious. And so those are the two things that we're sort of like looking at around this language right now. All right, lots of hands. So we'll go to Catherine and then Sam and then Blair. Oh, Catherine, go ahead. Oh, you're muted.
There we go. Okay. All right. Yes. Well, if ever there was a use allowed in the EFU or forest zone that cries out to be clearly defined in rule, it's home occupations. This is a use whose interpretation and application across counties is widely variable and inconsistent and often inappropriate. This is noted in 1000 Friends comments and OCLW's comments and in the staff report itself. Staff report refers to the ambiguity and breadth of the definition of home occupation, the very wide variety and intensity of activities that are allowed. I think this is clear evidence of a fundamental lack of clarity and widespread confusion. And for this reason, this issue is, I believe, well within the Commission's charge to use to us to reduce regulatory confusion, improve clarity, and facilitate the implementation of standards by counties. I like as a starting point what you just suggested here under sub A, but I want to make a few points as well. First, I think the current language puts the cart before the horse. Review standards make sense only in the context of a use that's defined, and home occupations are not actually defined. While the proposed language addresses scale and intensity of the prospective uses, it doesn't address the relational aspect between that use and the primary residential use of the dwelling. The proposed language misses the point of home occupations as traditionally and commonly understood in professional planning and legal circles to be accessory to the primary residential use of the dwelling. Second, the language throws the barn door widely open to all of these allowed in EFU zones, including many that would be completely inappropriate in conjunction with a residential use under any circumstances. Calling for the use to be significantly less intensive than otherwise specified in rule is not a measurable standard, ignores the primary residential use of the property, and would just generate more confusion. A use could be significantly less intensive than otherwise specified in rule, but still dwarf the primary residential use of the dwelling. And third, and most significantly, I think, the proposed language doesn't address uses not otherwise listed in rule that are nonetheless regularly approved as home occupations. This is where most of the abuse occurs. Again, for lack of a clear definitional accessory standard, home occupations in this category have become a catch-all, a go-around, and a veritable black hole. So I argue that the home occupation issue is well within the scope of the Commission's charge to us. It would be a relatively simple fix, something along the lines of the use being accessory, incidental, and subordinate. It's well supported by professional standards, and it's a definition that's in common use across the nation. Thank you.
All right, thank you, Catherine. All right, we'll go to Sam and then Mike.
So I am opposed to this language, and I am opposed to the department taking up this issue in this way. There is pretty well established case law that the statute that allows for home occupations is supposed to allow for variable uses. it is supposed to be pretty broad, so long as the use meets the factors that are outlined in statute to make it incidental to the residential use and to limit the size, scope, and scale of intensity. And that has been pretty clearly outlined by the courts, and that if the legislature wanted to make a change that is suggested here, they could have, but did not do so. And I also don't see how this works given other statutory language that makes clear that certain uses allowed on ag lands should have a multi-permitting pathway and are not only, supposed to be cited in one way. So I think that this limitation of you can not have uses if they exceed a certain size is a really significant policy change. It's a really significant limitation on uses. And I don't understand the reason why we would be doing this, except for the fact that it seems that some folks don't like it and they don't like what the courts have said. And I also think, sorry, just to add my last comment, because we brought it up earlier, that this could have some really serious implications for example, childcare facilities. If you review the meeting materials that were sent out, childcare facilities are discussed and related to home occupations in detail. And so if you, we're in a rural, a childcare crisis statewide. We're in a specific rural childcare crisis. We are Business Oregon, other agencies, including DLCE, are working to try to find ways to increase opportunities for childcare, particularly in rural communities. And so I don't see how this change does anything to make it easier or relieve the regulatory burden for citing childcare facilities. And also, when we look at the previous language for commercial activities in conjunction with farm use, if you can't qualify for a child care facility because you can't locate within an existing school or public center, but then you have to significantly decrease the size of it to be a home occupation, you're only left with being a commercial activity in conjunction with farm use, and you're not going to be able to qualify for that because there's no way to show that that's essential to the agricultural community or ag practices, whatever the language said before. So I see that this could be a huge problem, and that, has to be co-located within a community center or public or private school. So home occupations are often how childcare facilities are cited in rural areas. So I think that, again, this is something I've raised earlier of this. I understand the technical work group brought this up, but this is a really big conversation, and organizations and associations that would be impacted by making this change were not included in the original conversation. And we should really slow down and rewind this conversation if we're going to be talking about home occupations, because there's way more voices that need to be at the table.
Thank you. And so the proposal that requires them to be less intensive than the uses that have standards in statute and not more intensive, that's a concern for you. That
this whole
be
thing is
allowed to be more intensive than
this whole
what is otherwise permitted.
Yes, if it can meet the factors outlined in statute, which has the 5-employee limit, it has to be substantially within the residence. The legislature already put in sideboards on what a home occupation can be and cannot be. This goes way beyond that. And it imposes a limitation that I don't understand why there is a legitimate policy need for it, especially when at the last RAC meeting, the local government said they like having multi-permitting pathways. They like having flexibility. So I just don't, I think this could have some really serious consequences. I don't think it could potentially be allowed under statute. And other statute that makes clear that, for example, agritourism, that you could have multiple options to apply for agritourism activities. So I just think this is a really big bucket of worms, and we need to go back to the beginning of this conversation because we're working off of after the presupposition that this is a huge problem and so it needs to be scaled back, when I don't think that's unanimously that's not a unanimous opinion.
All right, thank you, Stan. So we'll have Mike, Blair, Charles, Gordon, and then we'll move on. All right.
Yeah. I don't really oppose home occupations. It's just when you get to the size and scale, and I certainly wouldn't oppose daycare operations, but again, it's the size and scale. And one of the things you see is somebody builds a huge building for home occupation, and other buildings normally associated with the use permitted in the zone. I would prefer if it was pre-existing buildings in the zone. And unfortunately, we've seen some problems with that type of wording where people just build an ag building one year and then the next year they have a building that's normally associated with uses in the zone to do something really unrelated to farming in. So I think there needs to be a fix on other buildings, pre-existing buildings as of 2024 or whatever. And I think you get into trouble when it's when a home occupation is operated by a resident. I believe a home occupation should be operated by the owner of the building and who is a resident of the building. I think that those two things give you significant protection. Thanks.
All right, thank you, Mike. So Blair, Charles, Gordon, and then we'll move on.
Thank you, Hillary. I had the chance to do a good bit of legislative history research on the home occupation statute. It was first allowed. It was I think it was in 1977, maybe 2 years after Senate Bill 100 was passed. And there was a good bit of concern about folks going, well, do we have to get a permit, for one member of a couple to possibly have a tax return business inside the house, or maybe take in some mending or fix some cars in the garage in the back? And the legislature was, no, that's what we call home occupation. The planners kind of said that, that's a standard thing, not just an EFU's issue. You have it in urban areas as well. And a home occupation is a business inside a home. So I think just that was it, right? It was like, and so of course you should have that in the EFU zone, like you have it in every other zone. But the understanding of what a home occupation was a business inside a home, not a business that's the primary use. So I do think it's difficult to figure out how to do this. I don't really like the language that the agencies proposed in terms of, because I just don't understand it. May only be approved if it's less intense, because like less intense than what? I mean, there's no intensity standards on schools or churches or community centers. So I'm not sure how that would apply. I do think it's brilliant to just put the definition in. It's a very straightforward definition and just saying this is a residence and the commercial use is secondary or accessory, and that would just help a lot. So I think that's a really smart way of dealing with it. I didn't come up with it, but I think maybe Catherine Daniels said it's quite clever and within the charge.
All right, thank you, Blair. Charles?
Yes, thank you. I actually think this language is pretty consistent with the way it's easy for us to read and interpret, and it's incidental and subordinate to the primary use, the residence. So you can't be more intensive than a residence, and then there are sideboards by the substantially within the dwelling, or limiting number of employees. They have to be a resident. So I think we're good with this language. We actually have even further standards that are applicable. So we're a little more restrictive than even the state language, but this looks good to us.
All right, thank you, Charles. Gordon?
Yes, I just want to make a couple of points. First of all, I think, we came up with this idea of the smaller thing as a result of the county input at the start of our meeting discussing this, where they pointed out that they would, tend to put people looking for really small uses into the home occupation bucket, which, by the way, remember, is still a type 2 use. It's subject to the farms and impacts test and other things of its sub 2 uses or in the Oregon revised statutes. The other point I want to make, the second point, Miriam Cecilia has joined us from DELC, the Department of Early Child Learning and Children's Services. I probably botched that. Sorry, Miriam. But just to listen, because they have some the concerns that we're working separately on an issue about regarding childcare facilities. I don't know if Miriam wanted to say anything, but anyway, she's here to listen, and we will be continuing to work on them because that is a legislative priority to look at increasing childcare facilities around the state. And one of the issues would be in rural areas, should they be encouraged to be on farmland as opposed to other rural lands? But that's something that's an ongoing discussion. The next thing I wanted to say is that the problem statement here was not home occupations in general. It was the multi-path permitting issue, and that the problem was involving issues that are already listed elsewhere in statute, and that's why we reference or rule. That's why we reference that rule section there. And the idea that someone would use the home occupation provision to essentially evade standards with perhaps a bigger use than would be allowed under the statutory provision. I don't think anyone, maybe someone will disagree with me, I don't think it was the legislature's intent to have home occupations be a big loophole to get something even bigger than is otherwise discussed in statute. But it is something that is certainly reasonable to be a lot smaller. If it's small enough that it doesn't require the limitations or standards that are otherwise stated for that use, then this language would allow counties to consider and maybe approve those uses. And then finally, the last proposal about the subordinate to dwelling is, it's admittedly not in the statute that the legislature wrote for rural areas. It is extremely common, if not almost universal, I think, in an urban context for home occupations. And so the department will certainly consider whether that's an appropriate provision as part of this, but it is certainly beyond just the issue of multi-path permitting that we've been discussing. So I just want to make those comments. Thanks.
All right, thank you, Gordon. So I do see there's some other hands up, but it is now 2:30 and we need to keep moving on topics. Let's see,
Hillary, can I just ask a housekeeping question? If so, like, I have much more to say on this issue. If it seems like we're having to move quickly and we're on a tight timeline. So at this point, I don't think we've gotten to much of an issue yet where it sounds like there's consensus. So what is the plan if we continue on and there's not really consensus on anything? What are we to expect? Are we going to be having more meetings to discuss these? Should we be setting up separate meetings with you to discuss these?
So,
Hillary, if I could just break in here.
Sure.
Samantha and others, I think if we were trying to reach consensus in this group, we'd be meeting for the rest of the century, I suspect. So that is not our aim. Our aim is to discuss these issues and take different viewpoints and go forward with the draft rule of the departments based upon your input. But if clearly, if you don't agree with what the department came up with, and I think just about everyone on this panel will probably disagree with something the department comes up with, there will be 2 public hearings before the Land Conservation and Development Commission to present both in writing and orally your concerns or agreement or disagreement with the rules. But we're not aiming for consensus because I think these issues are so controversial that consensus is not a viable option.
All right, thank you, Gordon. Yes, and I would encourage folks again to continue submitting written comments. We've received a lot of written comments, and it's actually been very, very helpful to keep the sort of discussion and thoughts moving forward. And I'll clarify that at the sort of end and wrap up. So we did not see too many comments on the firm impacts test proposal, and so I'll just ask folks how if there are still outstanding concerns about codification of stop the dump here. We had a couple of minor edits replacing some ands with ors that I don't think will merit the same level of controversy as CACFUs. but just wanted to quickly open up if there's any other concerns on this proposal. Seeing no hands flying up. Okay. And then let's see. So we had no comments again on the incidental and subordinate necessary to support. Hopefully our rule language reflected the conversation and concerns about the predominant farm use and multiple farm uses and what need to be accessory to that. Samantha?
Yeah, I think I just reiterate the comments that I think were made at the very first RAC meeting about the term, about these being difficult to actually apply for and do. Again, I don't see how you're going to make a you're going to be able to show that with substantial evidence that your pumpkin patch is necessary to support commercial agricultural enterprises in your area. I just don't think that these standards are reasonable. I understand that this might be, I don't even know if this is case law or whatever, but as we said at the very first meeting, I don't agree with the department's decision to codify standards that don't work and that are overly burdensome and could have a significant impact on the economic success of agricultural families in Oregon, especially when we are in a time when our agricultural businesses are under extreme economic pressure and experiencing significant regulatory fatigue. I don't think that this is the right approach, and we should be, again, having a robust policy discussion about whether our existing law, as interpreted by case law, actually works for people, or if it does not.
All right, thank you. So future policy discussion sort of on the events opportunities. Lauren and then Jim.
Yeah, I mean, I was gonna second what Sam said. I'm assuming that the comments, we're not rehashing kind of what has already been said. So I know that there's been a lot of discussion already about the previous one about the farm impacts test and this one too, about how someone would actually meet the burdens in practice on these and if anyone would actually get through these tests. And so I'm not going to reiterate some of the discussion that we've already had, and I'm sure you've had a lot of comments on those. So I just wanted to clarify that I know there's been a lot of discussion about these already, and so I still don't know.
All right, thank you, Jim, and then Mike. And then
Yeah, I
we'll
just
move
want to
on.
reiterate, the farm impacts test is a key hallmark of the exclusive farm use zone, and it has been going back before there was even a statewide planning program. It was part of the tax purposes and the like. Non-farm uses are not supposed to be easy to approve. They're supposed to be authorized when they are found to be compatible and not increase the cost of surrounding farming practices. The Supreme Court and the Stop the Dump case simply defined what that means. That's not a change in any policy or the like. I strongly support the implementation of case law. Since that has happened, there has been a lot more consistency in terms of the application of the farm impacts test.
All right, thank you, Jim. Mike?
Yeah, I sort of do agree with Lauren and Sam on this one to some extent. And that is that, the hope is that it's simpler and clearer. And sometimes we're not getting there. And I'd have to scratch my head 100 times how we do a better job of getting there. But my goal on all this was simpler and clearer and easy to determine. And unfortunately, we're not always getting there. Thanks.
All right, thank you. All right, Rob, and then I think we'll move on to talking about our FIS unless other folks have any comments or questions about the other items. It didn't seem to have a lot of feedback on. All right, Rob?
Yeah, if you could scroll down to the next page, please.
Yeah.
I would suggest on the very last line that's shown there in red, adding one word between the and commercial. I would say the entire commercial farm. We had a case where there were events approved that were shown to be essential for one of the minor, I'm sorry, on the very last line.
That one?
Well, I guess maybe both. I noticed it at the closer to the end of the sentence, where were events for it was basically an incidental farm use on a large farm, and the events were found to be essential for a non-essential part of the farm, and Luba found that you need to look at the whole farm.
All right, thank you, Rob.
Thanks.
All right, Lauren, and then Sam.
Yeah, I struggle with the entire commercial farm because our acreages are highly diversified. And so they could be doing something that is related to one of their crops and not all of their commercial farm. And that would leave that out. So, for example, Sam's pumpkin patch, right? They could have a lot of other crops.
All right, thank you, Lauren. Sam?
Yeah, I mean, at some point, like, could someone articulate to me how a pumpkin patch would successfully meet the standard?
For the agritourism event permit
Sure.
application? I'm sorry.
Yeah, you walk through how a pumpkin patch or harvest festival could successfully meet the standard.
So for anything that is up to 6 events, right, then this is the only section that is applicable. So if they wanted to host 6 events over the course of the summer, 6 72-hour events, then they would demonstrate that it's incidental and subordinate to the primary farm use on the tract in terms of its nature, intensity, and the economic value of the pumpkin harvest festival versus the farm use occurring there. If they want 18 events, which is a higher standard, and the legislature is clear that that for the 18 events, it should be a higher bar to meet. If you want 18 events a year, then the requirement by the legislature is that it's necessary to support the farm uses or commercial enterprises of the area. That's statutory language. What the courts said is they explained a little bit more that necessary means that they're essential in order to maintain the existence of either the commercial farm or commercial agricultural enterprises in the area. So the courts gave us some insight there into what it means to be necessary to support. And so you would demonstrate that your harvest festival is necessary for you to support your commercial farm operation. Perhaps it's your only revenue outlet for selling your pumpkins or something of that nature.
And if it's not your only avenue, then would this be approved?
So it would depend on the specific circumstances of the proposal and the operation. And
Hillary,
again, there's always the smaller.
Do you see what I'm saying here, though, Hillary?
Yeah.
How this is,
So
it
is your
doesn't
concern
seem.
with the statutory language or with the clarification from the courts?
My concern, I believe, is with the clarifications from the courts.
Okay.
And I just, how are you going to realistically say, if this is if you've got if you're in a jurisdiction where they're happy to work with you, happy to give you your permits, your neighbors aren't going to complain, you're in a best case scenario, this might not be a big deal, but that's not really how this plays out in reality. And so if you're not in the best case scenario situation, and you might have a neighbor that doesn't want you to have agritourism events, and you're likely going to have some sort of opposition to your permit, how are you realistically going to meet this burden? And this is for agricultural practices often. This is for farmers are doing this. And so that's where I really am concerned, and I struggle with this decision, and would like the department to scale this back and we reapproach this conversation, because I don't think this codification at the end of the day is going to serve the agricultural community. If it's not serving the agricultural community, then I don't think you're actually meeting the goals or purposes of goal 3.
All right, thank you, Samantha. Austin, and then we'll move on to our discussion of the financial impact statement.
Yeah, I just kind of wanted to touch on that point. We get a good amount of agritourism in Marion County, and I don't think it would be too hard for someone to show that, we use the Harvest Festival example, pumpkins. It's that I think it would be relatively easy to say that it's typical in the nature of harvest festivals, and selling pumpkins is that of U-Pick, and most people enjoy the experience of U-Pick. And there's really not many mail order pumpkin outlets out there. I certainly haven't heard of one. And I think you'd be able to argue and put findings in that this is a typical use that happens in most places. U-Pick by itself doesn't even require a permit. It's if you want to do the other things along with it. So you could argue that U-Pick is already permitted. It's a farm use. So that is the farm use that is essential in order to maintain the commercial farm. And then the Harvest Festival would be the other incidental along with it that provides more reasons for a family to come out there, more reasons to get people out on the farm. And I think the findings would actually be relatively easy to make for something like this. And I do think it would still be easy for people to get approved for agritourism if we're using the harvest example with pumpkins. It might be harder to say that we're going to do a harvest festival for green beans because most people buy those in a can, but there's still something to be said there. You could definitely do it, but I think with the pumpkin example would be relatively easy because that's an accepted farming practice and U-Pick. And I think the findings would be relatively easy for a farmer to show, and relatively easy for a county to implement and read through and make a decision on. That's what I've got just on those concerns. I think it would still be all right to have this language.
All right, great. Thank you, Austin. All right, so we are a little off our agenda today. So we are going to go ahead and move right now into the conversation about the fiscal impact statement. So a fiscal impact statement is required to go along with the notice of rulemaking when that goes out. So our notice of rulemaking, we currently anticipate that is going to be going out September 1st. And so that will include the statement of fiscal impact. And most of what goes into the fiscal impact statement is required by statute or rule. And it is meant to highlight positive as well as potentially negative impacts of the rule change. And that information, the statement is based on information that is generally available to the agency. The statements address the impact from the status quo as things, compared to how it exists right now over the rule change, rather than addressing, the entire rule. So we are specifically asked in preparing the fiscal impact statement to identify any significant impacts on businesses. And that can include things like cost of compliance, cost of equipment, supplies, labor, administration. And ultimately, the intent behind a fiscal impact statement is to alert the public to the possibility of financial impact of the rules. And that can assist them in determining whether they want to participate in the rulemaking or not. Gordon, do you want to add anything about a fiscal impact statement and the housing cost impact statement before we start taking comments?
Clearly, if you look at the statutory rule, there's in the department's opinion, no issue with the housing cost impact statement because the housing cost impact statement is entirely focused towards essentially urban housing and impacts on that. So the key thing for us in terms of the fiscal impact statement was the impacts to the general public, local governments, and businesses, particularly small businesses. That's what the statute says. And in addition, to point out that the issue here is not necessarily to completely make a decision based upon the fiscal impact statement, but to make sure that decision makers are fully apprised of fiscal impacts on those named people, which include the general public, that would result from the adoption of the rule. And that's what we've tried to do. And we've, clearly there are some areas, I think Samantha in one of our earlier meetings brought up the issue of record keeping, and we have addressed that in there. At least, regarding the proposal that we have put forward, at least as a draft at this point. Like I said, though, and there may be other issues as well, but the key issue here is not necessarily that this completely, overwhelms or completely drives the decision, but is a factor in making a decision that our commission will need to take into account when they make a decision on what rules to adopt, if to adopt rules at all.
All right, thank you, Gordon, for that clarification. So the rulemaking that we are considering right now covers a wide variety of topics. And so the impact statement is quite long. It's about 10 pages. And the impact statement is currently based on the text of the proposal that was in your materials packets and that we've been discussing today, just to clarify. You will notice in reading the physical impact statement, it starts off with conforming rulemaking. And so just as a heads up, we are including some conforming rulemaking items in this rulemaking. These are what a conforming rulemaking is legislation that is passed, and we are updating our rules to reflect the content of statute now. So that includes a 2019 bill that was enacted that did not make it into our rules, and so that's cleanup. And the modification to replacement dwelling standards that was enacted last year. And so you will see replacement dwellings in the rulemaking as conforming. I just want to clarify that so the people understand what that is. So when you get to the physical impact statement, the first section, all of the case law codification has been dealt with collectively. And so we have gone through them sort of as a block, looking at them together. So I'll ask folks if they have any comments, concerns, or questions about the way that we have approached characterizing the financial impact of codifying common law standards. Elaine?
Thanks. Thanks for the explanation on that. I don't have any specific comments at this time, but we will provide some. It's helpful to hear sort of the agency's explanation for how it was approaching the impact statement before providing those. So thank you. Those will be forthcoming.
All right, great. And then the next section in the financial impact statement addresses the rule language that focuses on repairing the circular definition of preparation. So are there any concerns or questions about our characterization of the potential financial impact there? No hands. It seemed like some of the concerns that we heard previously about the definition of preparation were resolved. And if there are any additional concerns about financial impact of that, please let us know. All right, so then the section on verification of income, that is drafted anticipating that it would not be a requirement. This was for counties to essentially audit particularly farm stands. And this is assuming using the tax return receipt, which is fairly simple. You press the button online or you call the IRS and you get that. So there is no additional financial burden of requesting something from an accountant or anything like that reflected in the financial impact statement associated with the proposal for verification of income. And so I know that there's still a lot of concerns and questions, around that particular topic, but we would love to hear from folks about any other concerns on financial impact of the verification of income that are not captured in our FIS. And so we covered in that sort of statement potential impacts to counties from compliance, potential impacts to small farm businesses or farm stand operators of compliance. And so if there are other potential impacts that we're not thinking of, we'd love to hear that from folks.
Hillary, if I could just add, if someone doesn't have something right away, but thinks of something later, these are not final. And if you do have a concern, I think Elaine offered to make some comments in writing, and we would certainly like to get those if you don't want to, you're not ready to bring anything up today.
All right, great. And then the last topic that's covered in the FIS are home occupations and potential impacts to businesses from the proposed rule language, as was drafted in the packet. So again, I'll just follow up and say, if you do have concerns, about how that's been characterized in the fiscal impact statement, we would love to hear from you if you don't have any comments today. And I'll clarify this when I send the meeting notes out on Monday. We'd love to have written comments. It'd be great to have them, sort of within the week by the 20th or so. But I'll clarify that again in the email that goes out on Monday. Okay. Were there any other comments on the fiscal impact, the racial equity impact statement, or thoughts on that aspect of the document? No? If not, then we're on schedule, which is great and unanticipated. So we'll take a 5-minute break real quick. And then when we convene again, just before 3 o'clock, we'll start into our discussion on replacement dwelling standards. All right.
And just on that, there's no, in the recent materials under number 7, that's the discussion we plan to have. Then there's no specific language that we were looking at today.
That's correct.
Okay.
LCDC asked us to discuss this particular topic.
Okay, thanks.
That was the request. All right, we'll take a quick 5-minute break and reconvene. All right. Everybody made it back. Hopefully.
Like we have a few stragglers. Like just about everyone.
All right, folks. All right, well, welcome back. Hopefully everybody was able to grab a glass of water, take a stretch.
I'm here. Let's just move. The other people can catch up if they're not here on time. I don't care. So Hillary and Gordon are doing fine. I need to take pictures and send them to you.
Aww.
But they're not goats, Hillary. They are sheep.
Oh, hopefully they're fiber animals.
Animals. These ones are. Anyway, at least Gordon will be.
Oh, no, Hillary's going to slaughter.
Oh, Hillary's not going to slaughter. Some little girl wrote her name on her ear tag. So she gets to stay. That's what happens. Neighbors bring their little grandkids or their little kids over and they'll say, "Oh, I got to see this baby. Do I get to name it?" And then they write their name on their ear tag and date it and who named it. We have Yak named by the neighbor's girl. I mean, it's just amazing what I have in my house, on my farm. But they wouldn't know if they went to slaughter anyway, because they never know once they get big. Once they don't give them a bottle, they don't know who they are.
I'd love to see the photos.
Okay, I'll have to take you guys some updated photos.
Thank you, Mickey. That's a lovely interlude while we're waiting for people to get back. So hopefully people are back from break now, got a good stretch, and are ready to get into the next discussion. So at our April LCDC meeting, in response to public comment and public testimony sort of received at and prior to that meeting, the commission asked our rulemaking advisory committee to discuss rules for replacement dwellings. So there is no language proposal associated with this item right now. We're having a discussion and reporting back to LCDC. So today I'm hoping to sort of collect thoughts and ideas about the replacement dwelling rules and trends in development of replacement dwellings for our consideration. So a replacement dwelling is a new home that replaces an older dwelling on a parcel. And in order to be replaced, a dwelling must have or have had, under certain conditions, a variety of qualifying features, like walls and a roof, and heating and plumbing and electric. And they have to have had those features now within 3 years, within the past 3 years of applying for a replacement application. So replacement dwellings are the most commonly approved dwelling type in farm zones, and they're the second most commonly approved dwelling type in forest zones. They are a sub 1 use, meaning that counties must offer them as an option, and they may not apply more restrictive standards than those in statute or rule. And when the dwelling is replaced, the old dwelling must be demolished, removed from the property, or converted into an allowable non-residential use. And it's we have had some discussion and comment previously in the technical working group on the converted to an allowable non-residential use issue that was cited as an enforcement issue often. All right. So I know that there are a number of folks on this rack who have had ideas here and submitted some comments to the department on this particular topic, and we'd love to hear from you. Mickey, you have your hand up first, so go ahead and raise your hand. And I'm sure, Blair, we would love to hear from you on sort of the proposal that you submitted into the department on this topic.
Well, I put it in my comments. So when DLCD met in Central Oregon, Jefferson County Farm Bureau hosted them to a tour. I'm sorry that you and Gordon weren't able to make it. And I think it was eye-opening to them. And the director had said, well, we never hear from young farmers, and she got to hear from young farmers.
Nice.
And replacement dwellings is one of their largest concerns because when they are not, the old language had a footprint, and agriculture went and changed it so you could move the site. Like here, a lot of the young farmers talked about, well, we wanted to move the existing dwelling out of there because we wanted to put a pivot in. So we needed to be able to have a new footprint. But we can't afford to have McMansions built when other people come in and buy the farm ground and put McMansions up, and then they don't farm it, it goes to sell. You can't afford it as a young farmer to expand, or as a new farmer try to buy it if the house is too expensive. So in my comments, I referenced Beachy Creek fire and what the legislature did. They put 120% on all houses that were rebuilt after Beachy Creek and Santiam fires. So I would like to see the department staff work up some language so we can look at it. I think we're always better on the rack when we look at something you guys draft up, and then we can comment on it than when we just start throwing things out there. So that's what I would like for you to do. Thank you.
All right, thank you, Mickey. So we're hearing some concern about the impact of larger scale replacement dwellings on the value of farmland. And also we've heard a number of proposals to look at language similar to that was adopted for emergency fire replacements that limits the footprint of the replacement dwelling to 120% of the original dwelling footprint. All right, we have Jan.
Hillary, sorry, can I ask a
Samantha.
clarifying question of Mickey? Sorry, Mickey, I accidentally came on late, and I know you talked a little bit at the beginning, so I missed the first part of your comment. Did you say that when there was a tour of Jefferson County Farm Bureau, this issue came up, and it was one of the things folks were concerned about with the county was that there was not limitations on the replacement of dwellings?
Yes, our Farm Bureau did a tour, and we had lots of people there from the county. We invited DLCD to attend, and we had lots of young farmers there. I mean, I call them young, they're probably your age. Anyway, that was one of the things, and we talked historically how the footprint used to have to be in the same location and why ag lobbied to have that changed. But now the problem is when young farmers or new farmers try to get into it, buy additional ground, if the replacement dwelling is too large, too expensive, overwhelms the property, then it's out of their financial reach.
So you
Did
would
that
like
answer your
you would-
question?
Yeah, so you guys would like to, so you would like to see a cap or greater restrictions on the size or whatever of the
If
replacement.
you read my comments that I submitted, Sam, those were the comments that the young farmers suggested. Either use Beachy Creek or up to 2,500 square feet.
Okay, I'll go look at those. Thanks.
But they were, all that was in my comments that were submitted.
All right, thank you, Mickey, and thank you for clarifying that for us. All right, we have Jan and then Catherine.
Yes, I would like to see a cap on the size as well. We see many McMansions being built in Clackamas County where I live, And I think that if we're looking at protecting farm and forest land, the legislature has looked at what the house size should be in wildfire areas. Those are going to be forest areas, of course. So some kind of a figure such as 110 to 120% should be adequate in those zones.
All right, thank you, Jan. So we have Catherine and then Jim.
Thank you. I agree with the two previous speakers that this is a use that's been abused over the years. Certainly, I have noted that, and I would like to see the use either phased out or limited in square footage, as others have noted, and potentially specifically allowed only under certain circumstances. Thanks.
All right, thank you, Catherine. Jim?
Yeah, I just wanted to remind everyone that if there was such a cap, 120% and or up to 2,500 square feet or whatever, that wouldn't preclude someone from getting a larger dwelling. They would just need to go through and get it approved as a farm dwelling or a non-farm dwelling. This we're talking about is replacement dwellings here. Otherwise, they could do non-farm or farm dwelling still. Those provisions are still there should they want to go larger than whatever requirements would come from this.
Thank you, Jim. Lauren and then Sam.
So just to clarify, so some of the replacement dwelling bills that we're talking about after those large fires, those caps and things, those came with incentives for expedited permitting and other things after the fires, right? So like those were one time so that they could get things moving for replacing their homes that burnt down, and came with other programs and incentives and things after those fires. This wasn't like, so I think that they're being talked about as like one and the same, like, oh, the legislature put these caps on their replacement dwellings, like it was just replacement dwellings, but it wasn't just replacement dwellings. It was after the fire with reduced cost for permitting, expedited permitting, like there were other things that came in conjunction with it so that families could get their homes rebuilt quicker and to work with the counties so that that could happen after they lost their homes in devastating fires. So I think like we have to make sure that we're framing it properly. And I think also the other thing I just kind of want to put out there, Farm Bureau, so the group that I represent, grassroots group, we do have a replacement dwelling policy that is very open to allowing those who have current dwellings to replace them as they see fit. And so we're going to really struggle in this conversation as to putting limits on what someone who has a current valid dwelling and wants to replace it does on their property. So just wanted to put that flag out there for everyone.
All right, thank you. Sam and then Blair.
I have a lot of concerns about this concept simply because I think we are missing some of the reality of what this is like for applicants, especially after people have lost their home to a fire or a disaster. I am currently working through the local government process right now with an applicant for a replacement dwelling. They lost their entire home, their daughter, and their 2 grandchildren in the fire. It was a complete and total loss, and it has been the worst thing that many of us could even imagine. And the process for them to get a replacement dwelling has been extremely difficult. There is no guarantee that they are going to get approved, and they have had to spend exorbitant amounts of money on consultants, which frankly they don't have, to even get to replace their home back to its existing footprint, to the point now where they're not even sure if that financially makes sense for them given the loss that they've experienced. So I hear folks saying this is something that is just abused. I have read the Farm and Forest report. I understand that some folks think it's an issue that counties have been approving these, and there's a sentiment that it's too easy. I completely don't agree with that. And I also think that if we're going to be talking about replacement dwellings, we really need to exclude people who have lost their homes to disaster. If you're just replacing, you know, an existing home, that might be a different conversation. But when we're considering equitable outcomes, to impose greater restrictions, make this more difficult, or impose limitations on people who have a total loss, it's really, I don't know. It's tough to go back and sell that to someone when this process is not that easy. And then last, I know folks are discussing an 125% cap, and I think that that's also potentially really problematic when you're talking about potentially the replacement of his, you know, very, very, very old farmhouses. We're in the middle of a housing crisis. We know that people are moving towards multi-generational households, and that people need to live in places where they can age in place. And a size limitation on potentially a very, very small home might not make sense for people now if they're going to be moving their the grandparents in, or their parents in, or their kids. So I just think that when we talk about this, there's a lot more nuance here, and I don't feel like that's it needs a lot more discussion.
All right, thank you, Sam. So Blair and then Amber.
Yeah, I think Sam raised a lot of good points. I mean, the original intent of the replacement dwelling provision was for people who had lost their homes to fire or natural disaster. And the idea was, in a time of stress like that, devastating loss, that they didn't have to have the additional problem of going through maybe a complex or expensive planning process. I'm surprised to hear that the planning process is complex and expensive, maybe in Jackson County, because these issues are allowed outright. And I'm wondering if it isn't really the building permits. But just that aside, that's right. It shouldn't be expensive and complex. The problem that's happened is because now it's not just going to those folks. What we found are a lot of perfectly good mid to early 20th century houses, beautiful grasswood bungalows that have been farm dwellings for centuries, maybe on 40 acres that have farmed as part of a larger farm that's actually a commercial farm, are bought by previously city dwellers who want to live in the country and have basically a country estate. And they have some means, so they buy the house, they tear it down, and they replace it with a multi-million-dollar house. And there's a lot of examples of that. And that might be okay if you were in a rural residential zone that's zoned for residential development. But in the farm zone, you end up converting that land to a non-farm use and making it unavailable to the agricultural area. The places like Washington County where you see these, and they have an increasingly shrinking farmland base, you're increasingly shrinking the amount of land on which agriculture can occur. So that's really the concern. If there's other ways to do it than limit the size, or if it should only be for certain kinds of applicants, I think that's great. But there is a problem now, and it really is, what's happening is very inconsistent with the purpose of the exclusive farming zone, and it's quite harmful. So I hope that we can find a solution. And I would encourage the department, I don't know how this is going to work out, to actually draft a rule. Someone else said it's helpful to draft a rule to discuss, rather than discuss once we've had a discussion here. So thank you.
Thank you, Blair. All right, we'll have Amber and then Mike. Amber, I think you might be on mute.
Apologies. Thank you.
Okay.
I wanted to echo what Lauren said regarding the size limitation that followed the Labor Day fires. So my understanding was there was an allowance to go up to a larger, up to 10% larger house. But that was through House Bill 2289.
And that was really an exemption or a simplification of the process. You could still go through the typical replacement dwelling process. So we had a lot of applicants go through House Bill 2289, but we also had applicants following the Holiday Farm fire go through the typical replacement dwelling process. We in Lane County have, we call it the same site standard in our farm and forest zones. And that essentially allows someone to go through a type 1 ministerial planning application if they are proposing a replacement dwelling within a 200 by 200 foot square that's centered over the existing dwelling. And that is integrated into our code with findings that meet the siting standards, so that someone doesn't have to meet the more discretionary siting standards and can go through that simplified process. So I am trying to understand how a limitation on the size would jive with our objective and our process to allow for a more simplified same site dwelling replacement process. I think I heard someone talk about the need to have more flexibility related to replacing dwellings destroyed by a fire or another natural disaster, and I wanted to echo that. That certainly resonates here following the Holiday Farm fire. And then lastly, I wanted to mention, we just went through a code amendment where we looked at an allowance for replacing dwellings in the floodway, and specifically allowing a certain percentage increase in size to dwellings in the floodway. And ultimately, we landed on a 50%, and that was following a lot of discussion through the appeals, or excuse me, the hearings process, and concerns that came up through that process were that if you're looking at a smaller dwelling size, like a manufactured dwelling potentially, it really doesn't build in a lot of flexibility for someone to grow their home size. So that's just something that we heard recently in a hearing. Thank you.
Thank you, Amber. And so just to make sure I get that right, your simplified replacement process is if they want to locate the replacement dwelling within a 200 foot by 200 foot square centered on the dwelling to be replaced. And then you have a streamlined ministerial review. And then for something that's outside of that footprint, you have like a land use
a type 2
permit, type 2 process. Notice. Okay. Thank you. So we'll have Mike and then Nellie.
Yeah, this is an interesting issue, particularly that what Amber said was very interesting. The same site idea is it maybe if you have it on the same site, you should be allowed to have a house that's somewhat bigger than some other standard. But because the main thing is we're trying to not mess up the farmland. And I've seen a number of them where a 7,000 square foot house goes in the middle of a 40-acre field of prime farmland. And it almost gets to the point at that point that it's unfarmable. The amount of turns you have to make and so forth just increase your costs astronomically. So it gets to be a real problem. The percentage thing is not always great. We had one farmer that said he bought a farm, had a 600 square foot house on it. And so that rule 125 would let him have an 800 square foot house. That's a little way too restrictive. 2,500 square foot house is a pretty dang big house. So I kind of like that idea. And maybe if you had the same site footprint, you got to have a little bit bigger house. But to me, this is really a next generation concern, a next generation of farmer concern. You can easily push the price of farmland to over $100,000 per acre by putting a big house on it. So to me, this is really an equity issue and a next generation issue of how do we keep the price of farmland down so that actual people that are not trust funders can buy a farm and farm. So this is really a next generation issue to me. Thank you.
All right, thank you, Mike. So we are Nellie and then Mickey.
Thanks, Hillary. In our work, we do see a lot of farmland appraisals, and we found that building size or envelope, especially for the residents, does have a significant impact on farmland value. That's for new or replacement dwellings in places that have been doing easements for a lot longer, like Hudson Valley, have seen that and had to, at least in their easement contracts, take sort of remedial measures around that so that farmers are not priced out from the land. So I just want to verify what Mike and Mickey have observed from our perspective, and that a very large home can sometimes be a white elephant that increases the property value far beyond what agricultural income can float in a mortgage, and can be a deterrent towards someone being able to access that property. And I think in terms of the replacement dwelling rules, we're not talking about requiring the new home to comply with the former exception. So if it's farm family, it doesn't have to comply with that in order to be a replacement dwelling. That's already sort of a concern of mine, is, could be used for any purpose, regardless of what the original justification was. And so I think it really should come with some other restriction. Maybe that is a percentage size with a floor, so like it can be at least, 1,000 square feet, or, X percent more. Another question I would have there is, what if there are serial replacement dwellings and, over time it just increases by 25%, 25%, 25%, then we have the same issue. But I just wanted to put out, I think that there should be some restrictions on that, especially if we're not requiring people to comply with the original exemption.
So Nellie is bringing up an interesting point of conversation here. So when replacement dwelling provisions were originally established, we're seeing replacement of dwellings that existed or were permitted prior to the implementation of land use. When House Bill 3661 was enacted in 1993, that introduced a whole bunch of dwelling types that have very sort of restrictive standards associated with them. And so now we are seeing replacement of dwellings that were permitted under the standards that were established by House Bill 3661. So a lot of record dwellings, you're seeing template dwellings, but also those restricted dwellings like primary farm dwellings and accessory farm worker dwellings, and family farm worker dwellings being replaced. And so that is an interesting point of conversation. The department has sort of taken the position that those are vested under the original terms of the permitting, just like you would it's a use that was permitted, and that use is what is being replaced. But there has been some, I would like to hear folks' perspective on that question as well. So I'll have Mickey and then Gordon.
I feel for Sam's story because she probably doesn't know this. I lost my home to a fire. And I can tell you every emotion you go through. But it was not any problem with the county on the replacement dwellings. It was usually the permitting process from the building code. So I do understand all that, but I also understand what our young farmers are telling us, what is impacting them in a bigger picture. And that's why I would like for DLCD staff to draft something and put some background in it, like what Hillary was just citing, and then us continue the conversation. And I do understand from Lauren's comment, I did understand it was tied to the Beachy Creek and San Am fires, but those were just examples I was using of what the legislature did. And then Lane County talked about how they had different tracks and you could do it. And those are all the things that today I hoped would come out. So staff could hear these different things and look at some language and put back, and then all of us can have an opportunity to comment on it and go from there. That is my whole goal, is to develop a conversation about this. And we are we need to recognize that replacement dwellings in farm or forest zones, if they're not an emergency due to a disaster, is different than a replacement dwelling in an urban or rural setting, and the impacts that can be seen from that. That's where I come from, looking at the bigger picture and not looking at the NIMBY me. But I did lose my home and everything totally to a fire. So I can honestly say I know every emotion that goes through that avenue.
Right. Thank you for sharing that, Mickey. Right, Gordon?
Yeah, I really appreciate this conversation. There's a couple points I wanted to make. I think that as the agency, we are looking, obviously, there's a lot of interest in this issue, and we are looking at going forward and looking at what we want to propose. I think before we do that, we need to get some more information. And one of the things that is very, I can think of a couple of data issues, one of which would be, I think, fairly straightforward to get with help of counties. The other might be a little more difficult. And the first would be what has actually happened with replacement dwellings, this difference in size between existing and new dwellings. And it may be that if we do a data collection effort and we find a certain breakpoint that makes sense, say, 80 or 90% of the dwellings fall within a certain size category, and then there are outliers of 5 or 10%, the kind that were on the slideshow that the commission saw at one of its recent meetings. That might be a good way to figure out a proper standard. The second issue, I think, that's interesting and might be more difficult to get information on, but we can certainly try, is that what is the difference in terms of the farm use on a property before and after the replacement dwelling? On one of these sites where a McMansion gets built, does the person lease out the rest of the land, and the farm income that's generated from the land is the same or doesn't go down? I mean, I think that's not the only issue with these. Obviously, we have lots of other issues with farmland pricing and impacts on surrounding properties from farm impacts from a new dwelling. But I think that would be an interesting question to figure out, is the building of these properties with oversized houses leading to a reduction in farm income value, which it goes to the state's farm economy. And the third thing I wanted to bring up was kind of more of a procedural issue, and that is what's the difference between a replacement dwelling and a remodel? I've seen quite a few quote unquote remodels as a city planner over the years, which where someone left one or two walls up and just built something completely new. And our rule would have to look at this issue as well. So it is a pretty complex issue, but we will be looking at it going forward to see what we come up with.
Thank you, Gordon, for setting the stage for some of that. All right, Samantha and then Rob.
I just wanted to provide a different perspective on things again. In my practice, we get calls about replacement dwellings every week. And more often than not, they are young folks who bought property, and there is a older farmhouse on it that is not very nice. And they would like to replace it to be a nicer house for them and their family. Or they do want it to be bigger because they have kids. And so I just want to say a lot of the people who are asking for replacement dwellings are people engaged in agriculture who want to be able to replace a home, not because they're building McMansions. I work a lot in the housing space. I'm not sure what we're calling a McMansion and what that really means, but I can tell you not very many people are out there just willy-nilly building what I would consider a McMansion these days. And so I'm not saying it's not happening, but I'm also saying that people are replacement dwellings and get lawful approvals for replacement dwellings, and they're re-putting up a modest home that just is better for them. And that's important for that young producer because they want a nice place to live. That's a better chance of longevity of that farm being successful because they've gotten that replacement dwelling. Conversely, or additionally, we also people get replacement dwellings because they do want to sell the property. And they do want to sell it, whether that to be other producers or whatever. And it's that those people are also farmers. And that sale of that property has an economic benefit for people who are farmers. And so I can totally appreciate that folks are concerned about there being barriers to entry for young farmers and ranchers. I 1,000% agree with that. But if that's the issue, there are way more things we can do to reduce barriers of entry to farmers and ranchers, and we can have a way better conversation about that would have a greater impact than potentially imposing restrictions on replacement dwellings that could have a lot of inequitable outcomes for people. So I will say I completely agree with folks that we need to have a conversation about barriers of entry to farm for people buying farms, but I'm not sure that this is the right approach. And if we're concerned about land prices, it's another thing to note that land prices are drastically increasing all over the state. If the price of farmland shocks people, you should look at a buildable lot inside of an urban growth boundary zone for residential use. That will really, really give you sticker shock. So I just want to say there are people out there who need the replacement dwelling statute who do not want to have and shouldn't have. It should be up to their discretion to do it, and they are farmers.
Shut up. All right, thank you, Samantha. So we'll have Rob and then Nellie.
Gordon asked what is happening with the replacement dwellings, and we don't have numbers, but I would point out that in my county, there's been a large number of replacement dwellings that became purpose-built short-term rentals, Airbnbs, we often call them. I mean, the most extreme example was one, it's a 9-unit hotel. I mean, if you drive by it, you would look at it and you would think it's a hotel. You wouldn't think it was a house. And it was approved as a replacement dwelling, but that's only the most egregious example. There are many in this county that are now Airbnbs and aren't residences at all. And that was the reason I raised my hand, but I also wanted to point out that the limitations that are being proposed wouldn't probably stop the folks that Sam was just talking about, the young farmers who want a modest replacement. I mean, we're talking about modest replacements here, and this wouldn't stop those clients at all. Just wanted to make that point. Thanks.
Thank you, Rob. All right, we have Nellie.
Thanks, Hillary. I just want to underscore Gordon's recommendation for having data on this. I think that would be super, super helpful just in terms of even figuring out what the parameters are. If there is a problem, what is that problem? And just understanding the demographics of who's living in the replacement dwellings. Is it owner operators or folks who are farming and leasing agricultural land, or and then what is the size of those dwellings? I don't know if that's something, it seems difficult to just GIS it out, but if that could be part of the next Farm and Forest report, that would be an amazing addition. So I just wanted to underscore that.
And thank you. And as we're thinking sort of about data collection efforts, are there areas of the state or particular counties where people feel like this is a more pronounced issue in terms of impacting land values than others? So I think I had heard anecdotally, Mike.
Yeah, certainly in Hood River County, it's an issue. We have relatively small parcels, unfortunately, and oftentimes, as I stated earlier, a big house is put right in the middle of the parcel. In a lot of cases, they're not farmed or by the owner ever again. They're farmed by someone who is willing to lease it. So, there is a real impact on farmable land long-term, which concerns me. But again, it's that same issue that, I think I looked at one, the price of the overall farm was 133,000 an acre for a parcel that was 40 acres, based on the real market value from the assessor's office. So it's a huge problem here, and I suspect it's a huge problem in some of the areas in Central Oregon. Drove through Pilot Butte, I believe it was, and huge houses all over the place. And I'm sure all that land, which normally would be 6, 8, 10,000 acres, now 150,000 an acre.
And so it sounds like looking at land values and change in land values and seeing if we could correlate that at all with replacement dwellings would be something that would be worth studying as well. So we'll have Lauren and Blair.
Okay, so I'm a little uncomfortable now because it seems like this is becoming a larger policy conversation that's going to have to take some research to get some more information. And it seems like if you need to go out and you need to get all that information, this becomes a topic that at what point is the policy discussion so large it should be directed by our legislature? I mean, our legislature hasn't asked DLCD to look at this and say, what parameters do you think should be put around replacement dwellings that we didn't put on them in the statute? And so like, at what point should that direction come from the legislature to DLCD? Or should you guys do the research and say, hey, legislature, it came to our attention, there's these issues around the size of replacement dwellings. So we did some research. Here's a report for you. If you would like to take up this larger policy discussion as our policy making body in the state and discuss whether or not you think there should be a bill to change the statute to put parameters on replacement dwellings as it relates to size or footprint, because this is a very large policy discussion that the legislatures dance around in different areas as it relates to different smaller bills. But if we're going to have to do, it just seems like this is getting a little bit large in scope of policy that may be meant for the legislature.
Hillary, if I could just, Lauren's raised an interesting question. I'd just briefly try to answer it. The agency has been given, legally a lot of scope to write rules that get into policy issues. And obviously we would check with our Department of Justice attorney about whether, getting into this area would go beyond the scope. My thought is initially it would not. But you are correct. There's obviously also a political aspect of this, is whether the agency wants to or feels it's appropriate for us to get into this issue that you're raising, and I appreciate that. Thank you.
Thank you. And I would just clarify that right now the commission has asked us to discuss the topic with the RAC, and I'm curious to sort of sketch out some of ideas, and when we communicate back to the commission, sort of the content of this discussion and some of the ideas that raised that we could engage in going forward into the future. All right, Blair and then Jim.
Yeah, I wanted to respond. You were sort of asking about areas where there was more of a problem, or that's not really how you actually said where you think the impact on land prices might be. You could follow them more closely. I think you'll find impact on farmland prices everywhere. So I think really sort of looking at your own numbers of where the concentrations of replacement dwellings are going will probably be a good indicator of like where you want to focus, and then also being diverse in terms of the state. That said, often studies are the death of policy, and we've often seen both LCDC or the legislature direct someone off to go off and do a study, and then nothing really ever happens. And I would hate to see that. This is a crisis, and I think, Hillary, you write the Farm Forest reports. I wouldn't have known about the crisis if I hadn't read the Farm Forest reports. So that's documented, and now we know a lot more. So we just urge you not. Good information is great, but let's just not extend the discussion and the response and doing something about it for years and years. Thanks.
Thanks, Blair. We'll have Jim and then Samantha.
Thanks, Hillary. Number one, I don't see this as a big policy issue. We're not talking about taking away the ability to replace dwellings. We're talking about ensuring that replacement dwellings are that replacement dwellings are not becoming something else that they weren't beforehand. You know, you talked about where are there problems, and like where I get the calls and the questions from are particularly related to short-term rentals. Hood River County, Wallowa County, Clackamas County, Central Oregon. These are all houses that were replacement dwellings that are now short-term rentals. And that means that the house is not only not available for affordable housing or not available for farm housing and the like or whatever, but it's didn't go through a farm impacts test for those basically tourist rentals or whatever, how they would or would not impact agriculture. So I don't see this as a big policy question. We're not saying no replacement dwellings. We're saying let's make sure these replacement dwellings really relate to what the primary use was before they were done. You know, they're not becoming something else. And we've all seen some of the pictures. I mean, there's a hunting lodge in Wallowa County that the house is just huge, and it started out as a single wide mobile home, and there's more and more of those examples. I'd also like to point out that short-term rentals, if you look at the Clackamas County case that came out of there, short-term rentals are not even supposed to be authorized in an exclusive farm use zone without first going through some other use than being approved as a residential use. Yet that's what's happening with these replacement dwellings. And by being a replacement dwelling, they're not having to go through that lodging review requirement that Clackamas County Luba case and Court of Appeals case said short-term rentals are not residential use, they're something else. And so I think it's really, really important that we understand, we're not saying no replacement dwellings. We're saying, let's make sure they are replacement dwellings as opposed to something else.
All right. Thank you, Jim. All right. And Samantha?
I take issue with the idea that this is a crisis. I think I reject the premise that counties lawfully approving lawful uses allowed by the legislature as any sort of a crisis. And I don't think there is any sufficient data to show that those approvals have had any significant impact on the agricultural economy. If you look at I've read that report. If you look at the data around goal 3 and how it's working, it's actually working pretty well. Again, that's really different when we look at the agricultural economy. The agricultural economy is struggling. That is an actual crisis. And there's a lot of things that we could be doing and conversations we could be having about ways we can change our planning system to support agricultural businesses doing better and thriving. That's not this conversation. Additionally, I want to add the actual crisis that is really well established and documented is our housing crisis. And so I, again, think it's concerning that we are talking about imposing limitations on housing. I understand that goal 10 potentially does not apply outside the boundary, though I think that's questionable now with ONA. And I think that we have a housing crisis inside and outside the boundary, and I'm not sure that imposing restrictions on housing right now makes a lot of sense. Again, I understand that folks might have concerns about the most extreme cases. And so I support the idea that the department should go out and collect more data so we can really understand the gravity of the most extreme cases, because we're going to be making changes to statewide law based around the most extreme. I don't think that's good policy making. And so I support that the department would take more of a better look at this and actually look at possible the reality of the severity, the reality of the situation, and whether or not we actually seeing a significant change from replacement dwellings to the ag economy.
All right. Thank you, Samantha. So are there any other final comments or thoughts or ideas for tools to address these concerns before we wrap up with next steps?
Hillary, sorry. One thing that we didn't talk about that was talked about in previous discussions, just one other way is to just simply say you can apply for a farm dwelling or any of the 7 to 8 different types of dwellings that are allowed as an alternative. So meaning you don't, why have a replacement dwelling? You know, if you're a farm dwelling, get another farm dwelling. If you're a non-farm dwelling, apply for a non-farm dwelling. And that goes back to your question that I don't think anybody really came back to, which is some of these are non-conforming uses, even though that's not really, that's been separated from the idea of replacement dwellings in Oregon. In fact, you have a farm dwelling approved as an $80,000 standard. That farmer showed that they were making money from farming, and they can replace it with a dwelling that's unrelated to agriculture and sell it to somebody who's not interested in farming. So I think that's a concern, and maybe another way to go at it, you know, is simply require the applicant to meet the existing criteria for dwellings in the farm zone.
And thank you, Blair. So either pursue a non-conforming review for dwellings that were established prior to land use laws, or to apply for a new dwelling under the current available options and standards for dwellings. That's sort of the idea. All right. Well, thank you, folks. This has been a very interesting conversation today, and I think the past couple of months have been really fascinating. You all are very passionate and dedicated, have really great ideas, and so it's actually been a very interesting project to work with, and this group has been great. So as far as next steps, internally, the agency staff will be considering comments that we've received today and, you know, throughout the whole process that we've been going through. I'll be sending out meeting notes on Monday. So if you have any edits to the meeting notes or any other final comments or thoughts on the rulemaking that's being proposed or on the fiscal impact statement, I'm going to ask that you have those into our department by the end of the day on Monday, July 22nd. And we will be considering your feedback, reviewing the language of the Department of Justice. And then, as I said earlier, our intention is to file with the Secretary of State at the latter part of August so that the draft rules that will be published in the Secretary of State Bulletin along with the notice on September 1st. All right, so that's when those that draft will be publicly available. The first hearing for the rulemaking is scheduled for the September LCDC meeting, which is going to be in Salem on either September 26th or 27th. The agenda that tells us which of those days will be finalized sometime at the beginning of September. And again, you are welcome, encouraged to provide comments to the commission on that agenda item. And I'll definitely send out an email to the RAC members with links to information on that commission hearing, just as I did for the April commission meeting. All right, so following that hearing at the end of September, it is possible that the commission may want us to convene again. So if that is the case, we will have a 6th RAC meeting in early October if the question, again, requests additional feedback from the RAC. So we will be sending out a doodle poll for you guys for availability during the first 2 weeks of October, just to get a placeholder meeting on people's schedules in case the commission does want us to meet again to get more feedback. We currently anticipate that public comment on the rulemaking will be closing on October 16th, and that the final adoption hearing will be at the LCDC meeting either on December 5th or 6th. And if you're scribbling frantically, don't worry, I'll provide all of that in the email that goes out on Monday with the summary of the conversation today. So anytime during that process up to like October 16th, you are welcome to provide comments on the rule language for the commission's consideration, right? The draft rules may be modified at any point up to adoption in December, as long as the modifications are within the scope of the rulemaking that is indicated on the Secretary of State filing. And that's the notice that's going out September 1st. Okay. So again, all of that I'll send out in the email to the group on Monday with the meeting notes. So, and again, in closing, thank you all.
Hillary, Elaine has a question.
Oh, I'm sorry, Elaine.
Thanks. Just to back up on next steps. So this is our last meeting, and I anticipate folks will be sending in written comments following the discussion today for the agency's consideration. What is the agency's steps going to be to decide what actually moves forward to file with the Secretary of State? Because based on sort of today's discussion and past discussions, it doesn't seem like there's any consensus on anything at this point. So how are you going to work to resolve that ahead of filing with the Secretary of State?
So I think we've been sort of expecting throughout this entire rulemaking process, and hopefully we made that clear at the beginning of the rulemaking that we weren't expecting consensus from the Rulemaking Advisory Committee. We are collecting feedback and input from the Rulemaking Advisory Committee members, and staff will ultimately be making the final decision through internal conversations and discussion with our director on what the final proposal will be. Yeah.
And are you planning to propose then replacement dwelling rule language to file with the Secretary of State?
Now, the request from the commission was that we discuss replacement dwellings, and we will include sort of a summary of the discussion in our staff report for
Okay,
LCD.
but no rule language for filing.
Correct.
Okay, thank you.
All right, so any other questions about next steps or other comments? No? All right, well, again, thank you all. We very much appreciate your time and support with this effort. It's well, 5 meetings has been a lot of meetings, 5 3-hour meetings. You know, maybe we will get to convene again in October. We will see. But otherwise, feel free, you know, to give me a call or send in emails or written comments other ways. And that goes for anybody who might be following along on YouTube as well.